Welcome everyone to the Federal Bar Association Ketam sections, the rounds, FCA news with Tejinder Singh. The rounds is Tejinder's regular analysis of noteworthy False Claims Act decisions and developments. I'm Scott Oswald, programming chair of the Ketam section, here with Tejinder Singh, who is a partner at Sparacino PLLC. Tejinder, hello.
Hey, Scott.
So let's start with Wisconsin Bell Inc. versus U.S. ex-rel Heath. November 4th, you argued for the relator before the U.S. Supreme Court, and the question was whether fraud against Universal Service Fund, which is a federally mandated and regulated pool of money, is actionable under the False Claims Act, even though the USF itself is privately administered and most of its funds never pass through the government's hands. The High Court considered two different theories that would allow FCA claims for fraud against USF, and the broader theory is that all of the money that is held and dispensed by USF is provided by the federal government, even if the government itself doesn't handle most of the money. Let's begin with this broader theory in Wisconsin Bell, Tejinder.
So the statutory definition says that it applies if claims are made to a contractor, grantee, or other recipient for money to be spent on a government program, and the government provides or has provided any portion of the money requested or demanded. The argument here is that because the Universal Service Programs, in particular the E-rate program, which is the program at issue here, a subsidy for schools and libraries, are so heavily overseen by the FCC, the money requested or demanded is effectively provided by the government, even if the government is not touching the money. And that argument kind of takes two parts. First, the money only comes into the fund because the government requires telecom carriers to pay it. It really looks in many ways similar to a lot of the ways the government raises money, for example, taxes or duties or other collections. The only difference is that it's paid directly into a private bank account instead of first going through the Treasury and then going into the private bank account. And then second, once the money is in the fund, the government is the one who decides who can get the money. There is a private administrator who actually takes care of handing out the money. But in terms of determining who is eligible and how much they get, all of that is solely a function of the FCC's rules. And the private administrator merely acts on the government's behalf. And so we say both in terms of providing money to the fund and in terms of taking money out of the fund, the government is the entity providing the money requested or demanded.
So, Tejinder, there's also a narrower theory of liability. It's based on the idea that at least some of USF's money is funneled through the government, which would permit FCA actions for fraud against the fund as a whole. Tell us about this argument.
So if the carriers do not make their required payments into the fund, the government can go after them. The FCC can try to collect the debt, the Treasury Department can get involved, and in certain cases, the Department of Justice can get involved. And during the time period relevant to the Wisconsin Bell case, the government collected about $100 million that way. Those dollars were collected by government agencies, banked in Treasury accounts, and then transferred to the Universal Service Fund. And because the statute says that it applies if the government provides any portion of the money requested or demanded, that any portion language means that even if the government's not providing all of it, as long as it's providing some, that's okay. And so the narrower theory, the reason it's narrower is because even if you accept Wisconsin Bell's argument that carriers are providing most of the money, not the government, it's very hard to say that the government is not providing at least this subset of the money, which it is literally handing over by itself.
So we're not fortune tellers at the rounds, but it's hard to ignore how many times the justices asked Allison Ho, who argued against you, to assume that she would lose at least on the narrow theory of liability. Tejinder, if the court were to decide the case on a narrow basis, what do you think about that?
So the Seventh Circuit in this case decided that there were three independent reasons why the False Claims Act applied. It accepted both the broad and narrow arguments about when the government provides money. It also said that because the Universal Service Administrative Company is an agent of the United States, that was an independent reason for claims after the 2009 amendments kicked in, that the statute would apply. If the Supreme Court says we accept the narrow argument and we say nothing about anything else, I think the functional effect of that would be to leave the Seventh Circuit's decision intact. If the Supreme Court says we accept the narrow argument but reject all the other arguments, then of course it's a different story. So it will depend a little bit on how the opinion is written. But I think the most likely conclusion, and as you say, we're not fortune tellers, the prediction game is hard. But I think the most likely outcome will be an opinion that says we affirm with respect to the 100 million, we don't talk about anything else.
Okay, let's turn our attention to Florida, and we have some fresh news in the U.S. ex rel. Zafirov versus Florida Medical Associates, a case in which the qui tam provisions of the False Claims Act were found by a district judge to be unconstitutional, in line with some of the musings that Justice Thomas had in his 2023 dissent. Tejinder, this potential blockbuster case for our section took on an important step at the end of October. Tell us more.
Yeah, on October 29th, both the United States government and the relator filed notices of appeal. When we last discussed this case, the decision had been handed down, but the notice of appeal hadn't yet been filed. It wasn't certain how that would be structured. Now it looks like what will likely happen is that there will be a consolidated appeal with the government and the relator arguing together that the statute is constitutional. The 11th Circuit scheduling process is still ongoing. I expect that what will happen is that the opening briefs for the government and the relator will end up being due sometime in January, and then the briefing will proceed from there, along with oral argument. So it will be a while before we have a resolution, but we know now that an appeal is underway.
All right, let's turn our attention out west. We have a couple decisions recently out of the Ninth Circuit. The first case isn't legally momentous, but it's fascinating because a railroad company filed an FCA complaint as a relator and pursued its Medicare fraud claims to trial in Montana, winning a jury verdict against a provider that had been a thorn in its side over claims of asbestos liability. The case is BNSF Railway Company versus the Center for Asbestos-Related Diseases, Inc. It's a great illustration of how an unconventional relator can use the FCA for unconventional purposes. A jury found BNSF's claims to have merit, and the panel of the Ninth Circuit affirmed the verdict, so taxpayers will benefit for sure. But Tejinder, what's your view on the relator's use as here in kind of an unconventional way of the FCA as a cudgel against its enemies? What do you think?
So I think that this is a situation where probably all's fair in war. If any entity, whether it's the big guy or the little guy, is defrauding the government in the course of conducting its business, I think it's fair game to bring an FCA action. I think I've been beating the drum for a while about how there should be more cases by outsider relators, including competitors, industry analysts, and the like. Such cases allow taxpayers to recover money without necessarily subjecting an insider whistleblower to all the travails of that process, all of the employment retaliation that can occur and the other challenges they might face. So I think it's important that companies look at the FCA, and if they see their competitors or they see others engaged in fraud in their industry, that they speak up about it and try to do something about it. And so that may not have been, the motivations may not have been purely altruistic, but I think it's a valid use of the tool and ultimately provides social benefit, as you say.
Let's move to the other Ninth Circuit case, Mooney versus Fife. The Ninth Circuit set some standards for how it treats claims of retaliation under the FCA, embracing the McDonnell-Douglas framework and saying that the FCA treats employees with compliance duties just like any other employee when it comes to retaliation. Tell us your take on this one.
Yeah, this is a cool case. So the Ninth Circuit here has analyzes a couple of issues of first impression in the Ninth Circuit about the structure of FCA retaliation claims and reaches a decision that it acknowledges is at odds with how some other circuits have decided it. So the first question that the Ninth Circuit gets into is whether the employee has what kind of burden shifting framework applies. In a lot of employment cases, once the employee makes a prima facie case of retaliation, the burden shifts to the employer to show that there was some legitimate reason for the adverse employment action, and then the employee can rebut that showing. There are two different tests that have been applied. The McDonnell-Douglas framework requires the employer to meet sort of a burden of production. Then there is another test that applies in First Amendment cases, the Mount Healthy test, which puts a higher burden on the employer to basically meet a burden of proof in rebutting the prima facie case. The Ninth Circuit here goes with the more permissive McDonnell-Douglas standard. So this makes it a little bit easier for employers to make the required showing than the Mount Healthy test would. It acknowledges, however, that the Third Circuit has a decision going the other way. This does seem to be the majority view of courts applying the FCA. So, but there is an acknowledged split about it. And so there may be further litigation on that point at some point. Probably not in this case, though, because here the employer doesn't win, despite the fact that it got the more lenient standard on this element. The second question that the court decides is it's asking, was the plaintiff engaged in protective conduct, and also did the defendant have notice that the plaintiff was engaged in protected conduct? And here the defendant makes an argument that some courts have accepted, saying when the employee is in a compliance role, then the mere fact that they are complaining about potential non-compliance does not put us on notice that they are complaining about potential FCA violations. And the court basically says, give me a break. There's no reason why this employee's role needs to alert you to the fact that they might file an FCA lawsuit. It is enough under the text of the statute, especially as amended in 2009, that they were engaged in activities that are intended to stop one or more potential violations of the statute. And so even though they're not telling you, hey, I might sue you, if they're pointing to conduct that would violate the statute and they're trying to get you to stop it and you retaliate for that reason, then you can be held liable. And so on that basis, the court adopts a test that I think is more employee friendly here, which again tees up a potential split with some other courts.
So finally, Tejinder, on Tuesday, we had an election. We're just a few days away from that date. We don't know precisely how that's all going to shake out, but we do know that Donald Trump will be the 47th president of the United States. And the last time that he was president, there were some real changes in FCA policy at the Department of Justice. Definitely a perceptible loosening of enforcement. As an example, the Brand memo in 2018, which said that the DOJ would no longer bring FCA actions based on a potential defendant's non-compliance with written DOJ guidance, sub-regulatory statements that illuminate the law. That's not going to be enough. The memo was then rescinded by the Biden administration's DOJ in 2021. Another example, in 2019, Attorney General Barr signed a memorandum of understanding with Ben Carson, then the HUD secretary, essentially giving HUD veto power over FCA actions, including qui tam actions against many federally insured mortgage lenders. Tejinder, is the past prologue for what we can expect from a Trump administration 2.0?
I think most likely, yes. The way I expect this to go, although, as you say, it's early days and things can become very unpredictable, is I actually expect the administration itself to be, if anything, slightly more aggressive about fraud enforcement on its own. Consulting with people I know who have worked in government through multiple administrations, many have told me that the Trump administration was actually one of the most aggressive previously about healthcare fraud enforcement. And I wouldn't be surprised to see the same be true again. You've seen a lot of rhetoric from the incoming president about the need to stop waste in government, the need to stop fraud in government, about how government programs are not being well run. There are proposals to put Elon Musk in charge of a commission to reduce waste. And all of that, I think, could lead to heightened action against fraud and waste in the government, which could mean more False Claims Act actions brought by the Department of Justice, maybe more intervention as well. At the same time, I did see, and I think others in our bar probably perceived as well, a sort of increased skepticism of some relators and of declined litigation. And so I wonder how that dynamic will play out in the new administration. If there are changes in personnel at the Justice Department, of course there will be at the top. How those priorities will be communicated is still anybody's guess. But if I had to make a prediction today, what I would say is I think we will see increased enforcement overall, but maybe not increased solicitude for private enforcement, at least in cases where the government doesn't want to intervene.
Well, Tejinder, we shall see. Thank you. And thanks to each of you for joining us for this edition of the Federal Bar Association Key 10 Sections, The Rounds FCA News with Tejinder Singh. We'll see you next time.